We are live on YouTube.
All righty. Welcome everybody to House Energy and Digital Infrastructure. And it is Tuesday, March 18th. And we are here today taking some ongoing testimony on H11, a consumer protection broadband bill. We'll go around, John, we'll go around the room and introduce ourselves, including our committee assistant and anybody who's joining us in the room. And then we'll turn it over to you and you can identify yourself for the record. And I believe I saw that you have written testimony that you turned in ahead of time. So we always appreciate that. I'm Representative Kathleen James from the Bennington 4 District.
Scott Campbell from Calgary Essex.
Richard Bailey, Lamoille 2.
Chris Morrow, Wyndham, Windsor, Bennington.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Dara Torrey, Washington 2.
Graham Klutner, Chittenden 13, Burlington.
Right, and Representative Sibilia will be joining us shortly. She's the bill's sponsor.
Jack Locker, committee assistant.
Gwen Zakov, lobbyist for the Vermont Community Broadband Board.
Great. All righty. For the record.
Right, and I'm John Bergmeyer, legal director at Public Knowledge. And do you want me to begin my testimony now or wait?
Yeah,
or...
that sounds great. We have
Okay.
We have it, and we can all pull it up on our own screen. So no need for you to screen share, I don't think.
No, my oral presentation is shorter. So I'll just begin. Well, thank you for the opportunity to testify in support of H11, the Vermont Broadband Consumer Protection and Competition Act. My name is John Bergmeyer. I'm the legal director at Public Knowledge, a nonprofit organization dedicated to promoting affordable broadband, consumer protections, and fair competition. And my longer written testimony has been submitted to the record. Today, Vermont consumers face real risks from unfair practices by broadband providers. The FCC currently lacks statutory authority to directly regulate broadband. This was a deregulatory choice by the previous Trump administration, which also happened to remove the ability of the FCC to preempt state regulation. And since then, courts have consistently upheld states' abilities to implement broadband consumer protection measures. H11 addresses several issues. First, it ensures that consumers must receive the internet service they're promised. Providers must deliver the speeds and performance they advertise. This is essential because accurate information allows consumers to make informed choices and hold providers accountable. And second, the bill rightly addresses the issue of data caps. These limits are usually unnecessary and unfairly penalize consumers without true network management justification. Eliminating or strictly limiting data caps helps ensure equitable internet access for all Vermonters, especially those in rural areas who rely heavily on broadband for essential services like remote work, education, and healthcare. Third, H11 strengthens net neutrality by clearly prohibiting broadband providers from discriminating against or prioritizing certain types of internet traffic. Vermont already requires net neutrality compliance for providers seeking state contracts. Codifying net neutrality protections clearly in Vermont law maintains an open internet environment and protects broadband providers from unfairly favoring their own services or partners. And additionally, while the current practice of requiring providers to certify compliance for state contracts is valuable, it should be clear that the requirement to follow net neutrality rules is more than a requirement to obtain a periodic certification, but is a direct substantive requirement for ISPs. The bill also promotes fairness and transparency in pricing. Providers often use hidden fees and misleading pricing practices to inflate costs, deceiving consumers who find unexpected charges after contracts are signed, or who find that unfair fees make it more expensive to switch providers. Fees that consumers cannot reasonably avoid, such as mandatory equipment charges, are unjustified if they could be included in the advertised price. Optional fees should reflect actual costs or be comparable to third-party options. And Public Knowledge would recommend that the Attorney General, after the passage of this bill, would adopt clear rules specifying what constitutes justified versus unjustified fees using the authority the bill grants. Clear rules from the Attorney General's office would greatly enhance consumer understanding and provider accountability. And the bill addresses broadband reliability during emergencies. Broadband is critical during disasters, enabling essential communications, public safety alerts, and services. Providers must maintain service during these critical moments without exploiting consumers through unjustified practices or pricing. Strengthening this provision, such as by requiring backup power systems or other resilience measures, could further safeguard Vermont residents during times of crisis. And finally, broadband affordability remains an important underlying issue. The strongest consumer protections mean little if Vermonters can't afford service. The bill promotes transparency in pricing and takes steps towards ensuring that all families, regardless of income, have access to reliable internet. Um, Vermont may also want to consider additional affordability measures, like requiring providers to offer low-cost service tiers or discounts for low-income households. Um, to conclude, public knowledge strongly supports H11. Vermont has a unique opportunity to set a positive example for consumer protection, competition, and fairness in broadband markets. And we look forward to working with you and urge you to pass this important legislation. Thank you. And happy to take questions. I don't know what your procedure is here.
Thanks, John. I have a question. I'm just looking over your written testimony, which, as you mentioned, is quite a bit more detailed. Could you talk a little bit? We have until 3:30, so we've got time. Could you talk a little bit more about net neutrality? Just remind our committee, what that is, how it's playing out. How you guys feel about the net neutrality provisions in H11, and maybe what you know about what other states do, if you do.
Yeah, net neutrality is the basic principle that ISPs should not really interfere with the content that consumers want to access by, cutting special deals so something works better than something else, or blocking access to lawful internet content and services. It has a very complex history on the federal level, as people may know. It was in place, out of place. Most recently, the previous Biden FCC's attempt to reclassify broadband as a Title II internet service under the Federal Communications Act was struck down by the Sixth Circuit, thus bringing us legally back to where we were under the first Trump administration, which was the elimination of the net neutrality rules, which in turn had been imposed by the Obama administration. So we've definitely had a bit of a seesaw on the federal level. And I think ultimately that just shows, why states that care about this, it's all the more important. A number of states have net neutrality provisions, some modeled like Vermont's current provision, which is just a condition for obtaining contracts. Apparently, ISPs first have to obtain a certification or, certify that they're complying with net neutrality principles. The current legislation, instead of restating net neutrality, it just sort of cross-references the existing provisions in Vermont law. I think that the way that those provisions are written, seems fine. I think it's a little confusing for me, just the way that the bill says, like, oh, now all ISPs just to operate have to obtain a certification. Like, I think that certification was just really a state contracting thing, and it would just be more straightforward to me to just have the provisions just be substantively stated more clearly to just apply to all broadband ISPs that operate in the state. With the certification just being, just for, state contracting, could stay there. I think having the state contracting piece in addition to the substantive requirements is actually pretty important, because if the FCC were to regain authority over broadband, or if there were to be a new statute or anything else, that could easily preempt Vermont's net neutrality rules. Like, I don't really doubt that in certain areas the federal government could preempt states. It's just that the current legal status is that it has not. But with the purchasing power, the state contracting, I believe that's immune from federal preemption, because Vermont has the right to spend its money as it sees fit. So having them exist in parallel does actually make sense to me. But I would say, it does make a little more sense just to have them more directly apply, like if that's the intention. And in terms of what other states, I think most famously California was involved in, pretty substantial litigation over net neutrality rules, which went further even than what are currently in the Vermont legislation, or what are in the what has ever been invoked on the federal level. Addressing a few things like data caps with a lot more granularity. So California has it. A number of states. I don't remember off the top of my head which states I'm kind of bad at keeping track of that, but a number of states do have substantive net neutrality laws in place that I think are pretty valuable. Though to be clear, my organization, despite perhaps the it's not going to happen in the near future with the current control of the FCC and the Congress. I mean, we still ultimately do think that at a federal level, we want to have like baseline protections for people that live in every state, not just California and Vermont, but people in Texas or Alabama deserve net neutrality too. So ultimately, we do support federal protections. But and like I said, this bill goes further than net neutrality in a lot of valuable ways.
Can you, and then I'll let other folks jump in. Can you just, at the very layperson level, give examples of, in the absence of net neutrality provisions, what kind of steps could an ISP provider take to, throttle data? What kind of things are we trying to prevent here?
Yeah, so I mean, one obvious way is, I think like the really, some of the stuff that people say, like, yeah, theoretically, without net neutrality, an ISP could just block access to websites that it didn't want you to access just because of mere disagreement. Obviously, I think that would be terrible, and almost every net neutrality provision addresses that. But what we tend to see more is how, for example, net neutrality intersects with the issue of data caps. For like if you have like a certain amount of data that you can use per month, you're going to be basically watching watching the meter, as you're streaming video or using video conferencing or any number of these things. But without net neutrality, an ISP could just say, well, we have a deal actually with Spotify and not Apple Music. So if you want to have a better streaming experience, go ahead and switch to Spotify, and that way you can listen to Spotify and not worry. And that's like a way of basically taking advantage of the fact that you own the pipe as the ISP to cut deals with content to basically push people to the content you want. Something that we saw, it's maybe you see it a little bit less now that streaming is like not just the future of video but the present of video for many people. But just a lot of ISPs happen to also be cable TV providers, and naturally, it's not a net neutrality issue to watch cable TV rather than using the internet per se. But by having the data cap set at a level that discourages high bandwidth uses, it's a way of basically, taking consumers and pushing them over into, different kinds of services. A lot of the violations we see are pretty subtle, but I think they just come down to the idea that we have these monopoly infrastructure providers, or they face very little competition. It's very hard to switch, and we think that these sorts of gatekeeper services shouldn't be in charge of, the content and services that people access over the internet.
Thank you. Other questions? Yep.
I want to follow up on
Okay.
the question that you asked and your response, John, around I just want to make sure I understand around the net neutrality provisions.
Right. Yeah, it just seems the way it's currently written, like if I'm an ISP, it seems like, well, the requirement is that I just go and acquire the certification and I just did it and now I'm done. And it's like, well, no, you have to I don't know what the procedures are in Vermont for like what happens if you obtain a certification and then like you sort of go back on your word. I'm sure that's unlawful. It just seems like instead of saying, hey, ISPs, go and obtain a certification that you're doing this, it's just the law should just say ISPs who operate in the state have to do the following. The requirement to first get a certification seems to shift the focus a little bit less on substantive compliance to procedure. Maybe it doesn't have any real effect because ISPs they see what's intended, but in other provisions of the law, like the unjustified fees, it's just a provision that says you're not going to do this, not, hey, go obtain a certification that says you're not doing this and then also don't do it. So it just seemed to me just as like a cleanup, as just like perhaps an unnecessary step. Although at the same time, I recognize wanting to maybe cross-reference your existing net neutrality provisions so you don't have two different provisions that maybe end up worded slightly differently or interpreted by some judge slightly differently in a different context. So having like that cross-referencing does make sense to me, as well as maintaining the state contracting requirement. I was just sort of questioning the certification step.
Okay. And I think that's good.
I'm just looking through your testimony to see if there's parts that I want to dive into a little bit more before we let you go.
Sure.
Mm,
In terms of, I have another question.
yeah, go ahead.
In terms of affordability, we know that New York put in place affordable plans, had, I'm not completely 100%,
Sure.
although it's a bill that we're looking at here as well, proposal. But then AT&T said they're pulling out. Can you just tell us, are there states that have instituted this successfully, or which states are we be talking to?
I think New York has really been, I guess, they're close by too. They've been kind of the vanguard on this point. The other affordability provisions that we've seen generally tend to be like conditions on grants, as part of the BEAD program, as opposed to like a direct requirement, as New York had. In terms of just the legal status, it's just interesting because this is one where, my organization, we were in court wanting the FCC to have more authority. Like I said, we still want there to be an FCC and to have nationwide net neutrality rules. But like a side effect of how the FCC did it was they, instead of just saying we have authority over broadband, yet we have decided, substantively light touch rules are appropriate. They said, well, we don't have any authority at all. So that removed their ability to preempt. Now, over in New York, if the FCC still had authority over broadband, maybe New York's affordability could have been preempted. So the ISPs were actually in a difficult position just because their main issue that they wanted was no Title II authority from the FCC, but that left them, I guess, from their perspective, more vulnerable to state level legislation. So they tried some tricky legal stuff and saying, despite the fact that we won on this issue of the FCC having no authority over broadband, they haven't like given up the ghost. They will pretty much litigate everything. And as you've seen, yeah, AT&T for a service which I think was somewhat of a marginal service. It was just like I think it was like a WISP service, so that's like a wireless service that is fixed and goes to the home. They said, well, this service is not going to be available in New York. I haven't really done the numbers to see like how substantial that is. I don't think that this affordability requirement is going to cause like the major ISPs, the cable ISPs, that serve millions of customers to decide to up and leave the state. But certainly to send a message or for other reasons, ISPs might make a decision based on what states do. Yeah, I hope I didn't get too confusing with the legal status there because it is very complicated with whether Title II is in place, what extent the FCC had to preempt. But right now the FCC has less authority to preempt, just given the legal status of broadband that they basically brought upon themselves.
So we had a pretty big briefing from our attorney on Title II. Yes. From Maria. When I don't know that everybody, maybe I shouldn't presume this, understands soft touch regulation.
Right. Well, yeah.
So this is the new committee.
Right. So I'm just saying, I would have been on the other side, but if I were advising the FCC against net neutrality, it would have been to retain authority and basically continue some, Title II authority, which is to say that broadband is a telecommunications service, much like telephone, and then just use your discretion to adopt like light touch rules. Like, in other words, not many rules at all. The statute just says things are unjust and unreasonable. I am a progressive net neutrality advocate. I have one view of what means unjust and unreasonable. But you could see maintaining Title II authority over broadband and just say, well, we think that almost everything is reasonable because the market is competitive or whatever. But instead of doing that, what the previous under Ajit Pai FCC did was they said we don't even have authority over broadband at all. So therefore, as it turned out in litigation, which to me was obvious from the beginning, if you don't have authority over something, you also lack the authority to preempt states, because preemption is just when the federal government has authority to passes rules, and they displace state rules. When an agency doesn't have authority, its desire that a particular service not be regulated doesn't have any legal effect. And that's basically what the FCC learned, and what a lot of ISPs have learned in like litigation over the New York Affordable Broadband provision, which my organization was involved in. We're involved in all the Title II litigation as well. So everything I say, I have a point of view on what the right outcome is. But I basically view the increased latitude for states to act as sort of the silver lining of what I think is otherwise a pretty bad state of federal broadband policy, where it's like, at least it opens up the doors for states to step in, because in the absence of federal authority, state authority to act is at its maximum.
So John, can you speak a little bit about what are the more common strategies that are employed by the telecommunications providers in opposition to consumer protection bills like H11? What are the things that we're likely to hear? So there's a new committee, they may not have heard these. What are the big compelling arguments that we will hear?
Yeah, I mean, so just I don't even view the requirement to have like a basic affordable tier for low income people as being price regulation, but I think ISPs have a tendency to categorize almost anything that they don't like. For example, measures about unreasonable or deceptive fees, or requirements on junk fees, things like that. They'll just sort of like characterize that as price regulation, in order to say that that's why it's extra bad. And they'll basically try to say, and a price regulation, like they'll come up with a theory where it's still preempted. So basically, nothing will stop, I think, a motivated large telecommunications company from attempting to argue preemption based on like whatever little scraps of authority they have. I would just say, just pointing to the New York case and pointing to the California case upholding net neutrality, we know that at least in most appellate courts that have looked at this, there's substantial room for state action. But my experience is that won't stop them from either coming up with legal authorities or just a basic policy argument, and oh, you're going to make it so that we can't invest. And therefore, if we can't, have these pricing practices that we want, that means we're gonna lose the ability to invest in broadband, and Vermonters will end up with worse broadband. We've seen these arguments for a very long time. Generally speaking, especially from my friends at an organization called Free Press, who have looked at this for a very long time, generally, at least at the federal level, the presence or absence of net neutrality doesn't really affect their long-term CapEx plans. Those are set like well in advance and just based on profitability, not necessarily like, well, we don't like this consumer protection regulation, so we're just going to suddenly, invest less money in Vermont. But they'll say it anyway. So that's, those are the kinds of arguments I'd expect. And usually the ISPs don't object to like the basic contours of no blocking of sites. Like they'll agree to that pretty readily. They'll often agree to not throttle traffic to competing services in terms of net neutrality. But you often see like, at the margins, like, how do you define blocking? How do you define throttling? How does it intersect with like data caps and billing? Are they just not allowed to like physically slow down a rival's traffic, or is just like giving preference in billing? So there's endless arguments that you're likely to see. I think just pointing to like the record of victories from states who have passed similar measures, and the fact that none of the arguments, there'll be a detail based on Vermont law or something that I don't know. Like apparently I put in the written testimony, there's like a Vermont Supreme Court case about VoIP regulation, which is, pretty complicated. But the ISPs have generally made these arguments over, consumer protection and net neutrality for many years, and I think that largely they're just fear tactics that don't really end up being borne out.
And Vermont actually was successful, I think, in our first go around with the net neutrality following behind California. We held our legislation. The chair wanted me to ask about consumer outreach plans.
Mm.
She's just left the room. Maybe I'm saying incorrectly. And your experience with successful ones.
Yeah, in fact, like my so we've had experience with doing like field hearings. My organization right now is organizing an event just about like universal service and broadband access in rural Ohio. I am not the person in my organization who necessarily arranges those or does the consumer outreach. I tend to focus more on the nerdy legal stuff. But I think the principle really is, and there's some, I think there's some other language in the bill on other matters that if people don't know that these rules are in place or they don't know the rules of the road, there just might be violations that they don't like pick up on. And I think part of, enforcement is you can't just rely on, the Attorney General's office to just go around and just like sniff out problems. You have to wait for complaints to bubble up. Complaints aren't going to bubble up if people don't know what is and is not allowed. So so that's one thing we found. And we've also found with like a lot of broadband, we're trying to reach people sometimes with it, with particularly when it comes to affordability and access things, as opposed to maybe net neutrality itself. We're trying to reach people who maybe aren't the most connected people, like almost like by definition, if we're promoting like broadband affordability and access. The target audience might be people who are less online, and therefore, like almost by definition, you can't just rely on online style outreach to reach those people. Very often, the most effective ways that my general community has found have been going on the ground and just like organizing and trying to meet people, meetings at libraries and things like that.
Yeah, and so, to this point, in terms of consumers' awareness that that they are being subjected to throttling or other net neutrality violations. That really feels like a pretty tall,
Right.
pretty tall hill.
Yeah, it's hard for sometimes people to know if their traffic is being slowed down instead of another thing. You might see something more obvious in just terms of, hey, this is going to be exempt from your data caps that'll be like written on your bill. But yeah, in terms of the actual measurement for throttling and stuff, that's one thing. But just in terms of just like basic knowledge of like the rules of the road, also when it comes to like fees, and that's like a big issue of mine. I snuck it in. Made sure I had it in the testimony. This issue of below the line fees is like really common in telecom, where and not just in broadband, but also in cable TV, where you'll have your price, and then they don't want to like appear to be raising prices, so they just start tacking new fees on. But they're not fees that are for like optional services or anything like that you could do without. They're just like mandatory fees that are just sort of characterized as somehow not being part of the price. And it's like just if people just know a little bit more that at least in this area that's not allowed. I think it could be helpful to sort of like surface issues of it happening. And like things like that people can figure out by looking at their bill might be a little bit easier for them to understand than having to measure the performance or lag on this or that internet service.
I think
That's a good question.
Rep Campbell, yeah.
So I was just going to ask John that your testimony is really helpful, and I wondered if you would be able to provide your oral testimony as well as your written testimony, because it was a very succinct summary of your written
Yes,
testimony.
I do. Yeah, I can email that right over. I'd be happy to.
Thank you.
Great. Well, right on time. That's a rarity for us. We have our next witness here on another topic. So, Mr. Bergmeyer, thank you so much for joining us. That was really helpful.
Cool. No,
And
thank you very much for inviting.
yeah, we appreciate your time.
Thank you.
Okay, take care. Bye.
Right. Rolling along. Senator. Do you want to scoot up?
I would love to.
Okay.
Super, thank you.
Yeah, we'll just introduce ourselves to you real quick since you don't know us, and then you can do the same. We're here now to do a sort of a bill introduction on S50. My name is Representative Kathleen James, and I am from Manchester.
And I forget who I am. I'm Scott Campbell. I'm Lieutenant John Bray, Caledonia, Essex.
Richard Bailey from Lamoille 2.
Tomorrow, Wyndham, Windsor, Bennington.
Michael Southwood, Caledonia too.
Christopher Howland, Rutland 4.
Territory, Washington 2.
Graham Sutton, Chittenden 13, Burlington.
Hello, it's good to meet you all. I am Senator Ann Watson representing the Washington District, which is Washington County plus the towns of Stowe, Orange, and Braintree. I know it doesn't quite follow the county lines. Odd. But anyway, here we are. So thank you for having me. So I am here to tell you about S50, which just passed the Senate. So S50 updates the thresholds for photovoltaic systems that would qualify for the fast or easy registration process through the Public Service Department. And it updates it from 15 kilowatts to 25 kilowatts. So some slightly larger photovoltaic systems would qualify for this faster registration process. And just to give you sort of an anchoring and how big that is, this is the kind of photovoltaic system that would probably fit in like a typical backyard. So the reason, one of the reasons that we want to encourage this, I think we do want to see more solar and more folks being able to have photovoltaic systems that are sized for the load of their house. And one of the ways that this, one of the reasons that 25 kilowatts was chosen was because if you consider the area that a 15 kilowatt system took up when the law was established in 2014, the technology has improved substantially to be more energy dense, so that in roughly the same area, you can fit now a 25 kilowatt system. So it is like a smidgen bigger, but it's basically the same size. And so, considering that technology has improved since 2014, it seemed logical to update this law. So we did have a couple of, we had a friendly floor amendment that passed, and that included some technical changes that were ensured that that 25 kilowatts specifically was included. Not like up to 25 kilowatts, it included 25 kilowatts. And then it did a couple of other things. One was that it required that these relatively small systems that go through the faster or easier registration process must follow local zoning setbacks. And I think that is a reasonable ask. We certainly want people to have good relationships with folks that have these photovoltaic systems. And so if following local zoning setback rules helps ensure that, then that was fine with us to keep the goodwill. And then the second thing it did was to allow a reassignment of where the recs can be assigned to. They can change it one time. Currently, there is no grace if you make a mistake on one of these small systems. I know, right? Where if you make an assignment of a rec on the paperwork and you either it was a mistake or you change your mind, that is it. Sorry, there's no changing it. And so we actually have a case which I can send you contact information if that is helpful, of a person, a developer who did make a mistake and tried to change it and was not able to, and cost them a fair bit of money. And so we don't want people necessarily changing all the time, just flipping back and forth. But if, let's say, it was a mistake and you want to make one change, this would allow them to do that. And if you're going through the longer process, it's just less likely that a mistake is going to happen because it is much longer, it's more involved. There's a lot more conversation. So I think it's reasonable to, have this provision for these smaller systems. So this bill was voted out of committee unanimously, vote of 5-0. And it passed unanimously on the floor of the Senate as well on a voice vote. So a lot of support, not thankfully controversial. So there we are.
Rep. Morrow?
Can you just give us a quick comparison of how it is now between the expedited permitting process and the regular permitting process?
Do you mean like what,
I mean,
how
what's the
involved
process? Yeah,
the?
yeah, just generally, like, are we talking, weeks and months for the long one and a couple of days for the short one, or what?
I think I'm going to defer that question to other folks that you might have in on this. It's a good question. I have my understanding of that answer, but I don't want to misspeak. So
Okay.
Yeah.
Fair enough.
From Campbell?
Sure, I'm gonna ask you about, this looks like a very good bill, by the way, but I'm gonna ask about the provision allowing the owner or the customer to change their decision about where the recs go. So the recs, just for people in the committee are still getting their heads around it, recs are generated in real time as electricity is generated by solar, in this case, solar panels. And if a customer decided to change where the recs are going, that would be restricted, or could be still be restricted by whatever contract they have with the developer who put in the rec, with the actual company that installed, and that's the solar panels. Right. So if I had Joe's solar company come and put in my solar panels, and I signed a contract with Joe's solar company that said you get the regs, then that is still control. That right? You see what I'm asking?
yes, so
What this provision is allowing is the original assignment of those regs in the application to the PUC.
right, this is about what the PUC would allow, or the public service.
Right.
Yeah. And so after that, it's a matter of how that contract plays out, but it's I imagine that would be part of the financial arrangement between the owner and the developer,
Right.
because it does affect the finances of the project.
Right.
Yeah.
Right. So it wouldn't allow a customer to renege on their contract with the developer, the company that put in their solar. I guess is what I'm asking.
Right. This does not, well, this would not, this doesn't speak to the contract specifically. It's just what the PUC or the Public Service Department would allow.
Right.
That's all I think I can speak to at this point. Is that, but I think it's a fair line of questioning.
Yeah.
Find out more.
I'm just trying to, clarify. Thank you.
It's okay.
Tori?
Thank you for this, Senator Wilson. I am remembering that we took testimony from the PUC on this last year.
Yes.
And did you as well? Because I'm wondering, did we not put it into one of our bills?
We didn't. We had it very briefly appeared in, I believe, a different bill. But then that language got taken out by the time, at least on the Senate side, by the time we got to the final draft. So I can't speak to what testimony you all took on the House side, but
We can be sure it's not already in law sometime.
we did talk about that. I'm sure it's does not exist.
Rep. Southworth?
Thank you. So presumably going from 15 to 25, you're looking to put more renewable energy into the grid, right?
That allow for slightly larger systems to be put up more easily.
Okay, but with that,
Yeah.
it would allow more energy in it.
That is at those locations, yes.
Okay. So did you look at the 2024 PUC biennial update of the net metering rate adjusters?
We of the net metering. So this is separate. This is separate from net metering specifically because it doesn't necessarily. It could be under a different program.
But it says net metering projects.
Oh, I'm sorry.
size of solar net metering.
Oh, I'm sorry. I apologize. Yeah, no, I think we did not look at those.
Okay.
Yeah.
My concern with that is, and this is quoting from that report, so net metering has played the most prominent role in the expansion of Vermont in-state renewable energy portfolio, despite being the highest cost source of renewable capacity in Vermont. So that says to me that it's going to increase costs for some Vermonters who don't participate in that metering. Would that be a fair summation?
That's a good question. There is, some concerns about net metering, having some cost shifts, but I think the amount, actually, I think we did take some testimony on how much that would be, and it is pretty minimal.
Yeah,
But there's- but
concerns
there-
have been pointed
Sure,
out, and there is going to
there-
be an increase to non-participants.
I think there are other people who can speak to that more specifically.
Okay.
Yeah. And the amounts. Yeah.
Senator Watson, I wanted to drop all the way back to 101 and see if you can just remind the committee or fill us in a little bit about who are the folks who are building and owning these types of projects? Are these regular Vermonters putting one up in their backyard, or these are utilities? Who is building
This size
of array?
Yeah, so my understanding is that these are mostly just your average Vermont homeowner that has some backyard space. So these are not big companies. They're not, industrial scale, like they're relatively small.
Okay. And I know we'll take testimony on this. I won't get you out of your wheelhouse. Okay. So this is primarily homeowners who want to put up a project and benefit.
Right.
Okay.
Well, I reviewed after Mr. Poirier came in about this because I have somebody in my area that may have mistakenly retained the recs. So I understood from reading that the retained recs was that the homeowner retained the recs, and a rec is about 1,000 kW becomes one rec. He generates 500 kW. He has half a rec. I equate it to a Canadian penny. You found it where you're going to sell it, and so he had a problem with that issue. I haven't heard what happened, but also, has anybody gone to the utility in what they addressed as constrained areas that if a couple of these go in on the end of the line, what happens with system protection to the utility? It could be a concern because too much energy being generated too far out may exceed the regular flow of electricity through protective devices.
Yeah, that's a good question. So there, even though this is a fast registration process, it is still subject to the distribution utilities. So they can still say, this location doesn't work for us.
So it's not an automatic.
Right.
It's still some review.
Yes.
And option for the utility.
Mm-hmm.
Yep.
Do 15 kilowatt projects require a certificate of public good?
That is a good question. I'm getting a nod, but I will let other people speak to that. I'm sure, yeah, I'm pretty sure they do, but I'll let other people speak to it.
All right.
Yeah.
Brooke Bailey?
Yeah, I've got a note from the village manager from the village of Hyde Park. Would you expound on what his concern was with this bill, but for his utility?
Yeah. So he had a concern about wondering if the larger system would require more staff for review. But it seemed that there would be some level of review that would be currently needed for 15 kilowatts. And so the thought was it might not be all that different for 25 kilowatts, though that was the concern.
And Rep Bailey, thank you for reminding me. I got a little bit behind on my email yesterday, so I received that letter as well, and we'll forward that to the committee. Right, I think, did he send it to all of us? Anyway. Okay, TBD, but we do have some written testimony from them. Yep, Rep Sibilia.
Just to follow up on Rep Southworth's comments and some of the actions that we have taken and what this is and what this is not. So last year with our res bill, we eliminated virtual net meeting offsite, which is different. That's more of the merchant where we have people making electricity for money that Vermonters should then have to pay for. And I understand that net metering, period, all the ratepayers are paying for, but these systems are really home size systems that people, and there's a push to eliminate those that there's a lot of love for those systems from a lot of Vermonters that have.
Absolutely, I'm not arguing.
Yeah. And then there was one other piece, which was that as part of that, removing virtual offsite net metering, there is still an issue that's in play that is fairly contentious around affordable homes, because they were also a victim of that, of the res bill, and are trying to figure out how to allow renewable energy there. This is also probably not the right size for those types of developments. This is really smaller, just in scale of the things that we've been doing.
Right, thank you for that. This was not envisioned to be a solution to the elimination of virtual group net metering. That's a different problem at a different scale that is worth addressing, but this did not do that.
Other questions or comments? All right, well, I was jotting a little testimony list and looking to see who you all heard from. So we really appreciate you coming in.
Yeah, thank you so much.
Yeah, thank you so much, Senator Watson.
Sure. Yeah, thank you.
All right, Jack, we can go off live. We have a 10-minute